Hi, welcome back to the topic of parent and children, part 2. We are still on the discussion of guardianship and custody. Our next discussion revolves around a number of cases which illustrate how the court applied these factors in deciding custody of a child. Before that, I would like to quote what has been said by Justice Ajaib Singh, as he then was, in the landmark case of Mahabir Prasad and Mahabir Prasad on factors that must be considered in order to decide on the question of the welfare of the child as the paramount consideration. It is well established that in an application for custody of a child, the court will, in exercising its discretion, regard the welfare of the child concerned as the first and paramount consideration. It is equally established that this does not mean that the court will not take other relevant factors into consideration. Indeed, in order to decide on the question of the welfare of an infant as of paramount importance, it is necessary to take into account such matters as the conduct of the parties, their financial and social status, the sex and age of the child, his wishes as far as they can be ascertained, depending on the age of the child, the confidential reports which a social welfare officer may put up, and whether, in the long run, it would be in the greater interest, welfare and happiness of the child to be with one parent rather than with the other. But always, it is the welfare of the child which is of paramount importance. We have a number of cases which illustrates how the court applied these factors in deciding custody of a child. The first case is Teh Eng Kim and Yu Peng Sion. In this case, the wife made an application for the custody of 3 children, aged 15, 10 and 5 years respectively, in order to take them to Australia as the wife wanted to remarry an Australian. The husband had since remarried. The children were interviewed by the learned judge. The 2 elder children, aged 15 and 10, had expressed no affection for the stepmother and wanted to stay with their natural mother in Australia. The court was of the view that the maintenance of a stable and secure home in which the children can enjoy love and affection seemed to be the most important thing that should be taken into consideration in that case. The issue here is how far wishes of the parents are considered by the court. In this case, Justice Arulanandam granted the custody order to the wife, holding that the paramount consideration is the welfare of the child and no parent has a prior right. As the welfare of the children is the paramount consideration, the welfare of these 3 children prevails over parental claim. Parental rights are overridden if they are in conflict with the welfare of the child. But if the welfare of the child is equally balanced with either of the parties, the wishes of the parents might tip the scale. In the case of Chua Tai Peng and Kwan Hua Ong, a child aged 7 months was left with the maternal grandmother just before the parents' death in an air crash. The paternal grandparents later applied for custody of their grandson. The court held that the infant's paternal grandparents would be the more proper person to bring him up as a Buddhist, which would have been the wishes of his parents if they were alive, and thus custody was given to them. To what extent are wishes of the child considered and followed by the court? Section 88, subsection 2 of the LRA provides, the court shall have regard to the wishes of the child where he or she is of an age to express an independent opinion. We can see previously in the Teh Eng Kim's case, the court considered and followed the views of 2 of the children aged 10 and 15 years respectively. In another case, M. Saraswati Devi and Montero, the opinion of a 14-year-old boy who preferred to stay with the father was accepted by the court. In this case, the boy felt more at ease to live with the father, who lived in more familiar surroundings to the boy compared to the mother who had moved to a new place. The next case is Lim Fang Keng and Toh Kim Chu. In this case, the marriage of the parties had ended up in divorce. By a deed of settlement, the plaintiff, which is the husband, was to have custody of 2 children of the marriage, aged 11 and 9 years respectively. The wife subsequently withdrew her consent in the deed of settlement to confer custody on the husband. Instead, she filed a custody suit. Before the hearing, the wife embraced the religion of Islam while the husband remained a Buddhist. The children preferred to be with their mother instead of their father. In granting custody to the wife, Justice Suryadi applied, inter alia, the following principles. The paramount consideration is the welfare of the children, and children of tender age are not to be deprived of the love, care and devotion of their natural mother. In another case of Chan Bi Yen and Yap Chi Kong, the wife had earlier obtained an ex parte order granting her custody of her son, aged 7 years old. The husband applied to set aside the ex parte order. In granting inter partes custody order to the wife, Justice Peh Swee Chin applied the following principles. First, the paramount consideration is the welfare of the child, but this is not the sole consideration, though it is predominant. And subject to this, the wishes of the unimpeachable parent prevail over those of the other, following the case of Manikam. Second, the age of the child, which is 7 years old, comes within the rebuttable presumption under Section 88, subsection 3, in that it is good for the child to be with his mother, and the mother did love the child more than the father did, and the child has now represented the only meaningful thing in life to her. In another case, Manikam and Inter Rahni, the wife had left the matrimonial home and had taken the younger child aged 4 years to live with her in Muar. The elder child, aged 8 years, remained with the husband in Johor Bahru. The husband had taken a second wife with whom he had a child. In this case, custody of the 2 children of the first marriage was given to the wife. The husband's appeal was dismissed by the Federal Court through the judgment of Federal Justice Wan Sulaiman, who applied Section 88, subsection 2B, and affirmed that the welfare of the children is the paramount consideration. The elder child, aged 8 years old, could not reasonably be expected to express any independent opinion on his preferences. The wishes of the unimpeachable parent prevail over those of the other, and the care and attention of the natural mother can reasonably be expected to be superior to that of a stepmother, particularly one who has a child of her own and with every prospect of additions to the family. Now let's take a recap on the cases discussed just now to see the patterns of the court in deciding custody cases. We have Mahabir Prasad's case, where children aged 7.5 and 8.5 years respectively were given the opportunity to express their wishes, whereas in Chang Ah Mei's case, the court gave an opportunity to a 10-year-old child to express her opinion. In Lim Fang Keng and Toh Kim Chu's case, the views of 2 children aged 9 and 11 years respectively were considered and accepted by the court. So from these cases, it appears that whether a child can be considered as mature enough to express his or her wishes and whether the wishes will be followed depends greatly on the opinion of the judge in that particular case. In the case of Laura Doris, anak perempuan Lawrence, and Turai Singgam, anak lelaki James, High Court stated that the welfare of the child depends on many factors. Among others are age, gender, physical and mental health of the child, physical and mental health of the parent, lifestyle and social factors of the parent, love and emotional relations between the child and the parent, and also the ability of the parent to give guidance to the child. Next, ability to support the child with food, clothing, medical protection, the lifestyle of the child, quality of the school, and this is important if one of the parent wants to move from the current place, and the ability of the mother or father to build a good relationship of the child with another party. In another landmark case of Mahabir Prasad and Mahabir Prasad, in this case, the husband, a Malaysian citizen, had applied for the custody of his 2 infant daughters, aged 7 years and 8 years respectively, who were staying with his wife, an Indian citizen in India, until 1978. The husband had returned to Malaysia since 1974. In 1980, the marriage broke down. The parties entered into a deed of separation, of which custody of the infants was given to the husband. The wife returned to Bombay and subsequently filed a divorce petition inclusive of a prayer for the custody of the infants. The Bombay court made an interim custody order in favour of the wife. The husband then applied for the custody of the infants in the High Court Kuala Lumpur, but he failed as the learned judge was of the view that the husband was stopped from making the application in view of the decision of the Bombay court. Chief Justice Raja Azlan Shah discussed what will be in the best interest of the 2 children and what will be best to promote their welfare and protect their rights. In considering their welfare, amongst other things taken into considerations are the conduct of the parents insofar as it might indicate their future behaviour, the question whether the children of tender age should be with their father or mother, the situation in Bombay and Malaysia, the wife's apparent ability to spend some long and continuous period with the 2 children in the immediate future, the present situation where the children are brought up by the father's own family, the confidential reports of the social welfare officer, and the firm wishes of the children who want to be with their mother. Justice Ajaib Singh held that, from all angles, it was in the best interest and welfare of the children that they live with their mother, thereby dismissing the husband's application and granting custody to the wife. The husband's appeal to the federal court was dismissed, since the welfare of the children must be in the first and paramount consideration in such cases, and other considerations must be subordinate. Chief Justice Raja Alan Shah, in delivering judgment of the federal court, held inter alia that it could not be but for the children's interest and welfare that they be returned to the mother. To conclude from the decision of the previous cases, it shows that the pattern of the courts in deciding a custody case is, after taking into consideration of all material facts, utmost importance should be on the welfare of the child over and above all other considerations. You may also refer to a few other cases as listed here for your future understanding of the topic. And that is the end of part 2. Thank you for listening.